Thank you, everybody, for being here. This presentation will be a 2-hour discussion about protective order law and is a general discussion of civil legal resources that are available for survivors in Indiana. And we'll talk a little bit about ourselves, but before we get started, because I am a lawyer, I do have to make it really clear what we are here to do and what we're not here to do. So I do want to make sure that everyone understands that the information I'm giving you is in addition to other stuff that is available. So this isn't instead of safety planning. This isn't instead of calling the police or speaking to prosecutors or DCS. We're here to talk about civil legal options that exist alongside other things. And also, we're talking about this information generally as it applies in the state of Indiana. So we're not talking about how this would work if someone is not in Indiana. And we're not talking about how this will work in any particular case. I always recommend that people speak to a lawyer about how the law affects their case individually if they have the ability to do that. Otherwise, I am going to provide a list of resources for people who don't have access to a lawyer to learn more about their situation and to represent themselves. So we will be focusing on information today and not specific advice about any situation. I also want to emphasize that, as I'm sure you all know, that there are situations where you're required to call DCS or speak to Adult Protective Services, and that will kind of be part of the presentation in a couple spots. But that is something that we have to deal with as people who are working alongside children who are experiencing violence or families that are experiencing violence. And so that's something that I'm going to bring up in a couple other spots, but I'm going to lead with that as well. Okay, let's jump into it. So our goals for today are to introduce you to the organization we work for, Indiana Legal Services, to learn about some of the basics of protective order law, to give you a little bit of an overview of civil legal resources and how the process of getting a protective order in Indiana works. And I'll briefly touch on, if we have time, some of the other ways that domestic and sexual violence can interact with civil law. And I hope that we will have plenty of time for questions from you all. I would encourage you to put any questions you have in the chat while we're going so that whichever one of us is not talking can follow along and interrupt where appropriate or to make time for those questions to get answered as we go. And we'll also hopefully have some time at the end of today's presentation for questions. But again, we're not going to talk about specific cases. We're not going to get into the specifics of most of the areas of law that are related to these issues. We're definitely not going to talk about criminal law very much. However, if you have a specific case or a specific other issue that you need assistance with later, you should definitely reach out to us and you'll have our contact information after today's presentation. So the first thing I want to do is introduce you to who we are. Emily and I both work for Indiana Legal Services, which is Indiana's largest and only statewide legal aid organization. That means that we help people for free in civil cases where it's not usually possible to hire a lawyer without some sort of upfront payment. We float around 100 lawyers and about 50 other staff spread across the entire state. We do not do cases where you can get an appointed attorney or where an attorney will usually represent someone without upfront payment. So that means we don't do personal injury, employment, or discrimination, or some social security cases, because you can usually hire someone without paying them up front. And we don't do very many DCS cases or adoption cases because you have a right to an appointed attorney, and we never work in criminal cases for that reason. We do represent clients in eviction cases, family law, benefits, government benefits cases, consumer protection, expungement, unemployment, foreclosure, bankruptcy, driver's license reinstatement, immigration, protective order, and a lot of other types of civil and administrative law cases. We go to court with roughly 3,000 people each year, and we assist about another 10 to 15,000 people with legal advice or other brief services. So we make contact with a large portion of the state every year. It is still only about 10% of the people who need a lawyer who are low income and have reached out for some kind of help. But when we can, we do as much as we can for the folks that reach out for our help. In addition to our regional offices that are just in different cities around the state, we have several specific projects that serve a certain client population, including a senior law project, a military assistance project, low-income taxpayer clinic, immigrant and language rights center, an LGBTQ project, a workers' rights and protection project, which includes an anti-trafficking attorney, a program focused on vulnerable adults who've been the victim of crime, and medical legal partnerships that collaborate with different clinics and hospitals around the state. Emily and I work for a grant project in Indianapolis, though we are both able to work on whatever cases around the state we would like, that is focused on serving people who've experienced domestic violence. So we have two attorneys in Indianapolis, Emily and I, who can work statewide, and a paralegal who mostly does cases for us. And I'm going to let Emily give a little personal intro before I do mine.
This is one of my favorite trainings that we get to do each year. I don't know, if it might be our fourth year doing it now. And I've been in this work for about 16 years. I have pretty exclusively worked with survivors of crime, domestic violence, sexual assault, touched on some human trafficking with some cases. So this is my passion population. This presentation will be super interactive. Please drop in your questions. So again, I have a master's and bachelor's in social work. I've worked at ILS. It'll be 7 years in January. Work that we do across the state. As long as you self-report domestic and or family violence, we can work with you. So it could be a bankruptcy case where someone's experiencing domestic violence. It can be an expungement case where someone has a history. And it's really great because we have a lot of leeway within our work to connect with community partners across the state. We provide a more holistic wraparound approach in terms of services. I don't know if I'm supposed to talk about our project yet, but I'm Emily Hickman. I work on the Domestic Violence Victim Advocacy Project with William. Like he said, we serve the entire state, and my job in this role is to help clients address non-legal barriers to help them through the legal process as they move through it with whatever kind of civil legal aid law that they were initially connected through ILS to. So yeah, that's a little bit about me.
Well, I will add that I think, unlike most lawyers that work on domestic violence cases in Indiana, having Emily as part of our team means that our clients have a very strong connection between their lawyer and the other social services that they're engaged with. The whole goal of having our grant project is to be part of a holistic solution to our client's domestic violence situation. And Emily is definitely the glue that makes that work. There are lots of great examples of how that has worked over the years, but as advocates, I'm sure you can think of a lot of things that come out of having access to social services in addition to legal help. And I'm sure we'll mention a few of them over the course of the next couple hours. When I became a lawyer in 2016, I started working as a lawyer at a small law firm in Bloomington, doing family law, and quickly focused my career on domestic violence. And the next year, I came up to Indy and joined Indiana Legal Services. And over the course of that year, started the grant project that we work for. So now we have been doing that for the 7 years or so that Emily has been with us. Um, yeah, we've probably helped like 1,000 people over the course of the last 8 years, um, or 7 years. And we are hoping to keep doing that indefinitely. Yeah, Emily's asked, what organizations do you all work at? If you could drop in the chat where you work and maybe what your familiarity with protective orders is, if you've done like 0, less than 5, less than 10, something like that, so that we know how in the weeds to go as we are talking about this today. Just to back up to our organization a little bit, obviously the thing that you need to know the most is how to reach out to us for help and when to reach out to us for help. The best way to reach our staff is to apply through our centralized phone intake, which I'll include links and stuff to that in the PowerPoint here. It's normally available Monday through Friday, but this year we have been doing Monday through Thursday because we have had to dial back some staff stuff. And we are open 10 to 2 on each of the days when the phone line is open. So I recommend calling at 10 a.m. on any given day, any given weekday, and you will get connected to somebody. If there's an emergency, we have an attorney on call as the emergency attorney every day. And what will happen is within a couple weeks, you'll get a response back unless there is a deadline within that time period, and then you'll probably hear back faster. When we have someone who doesn't have U.S. citizenship or is not a permanent resident, we do have staff who are trained to collect the visa information that we need to determine if someone is eligible, and for people who are undocumented to collect the information we need to show that they are one of the people that we can represent. Unfortunately, because we receive a lot of federal money, there are some immigration related limits on who we can assist, and there have been since the 90s. Those have not been disrupted very much so far during the new Trump administration, but we do still have to ask certain information, but that is only for deciding who's qualified. We obviously do not share any immigration information with the government. But yeah, please go to our website, familiarize yourselves with how to apply. We do also have an online intake for people who are unavailable during our phone intake hours, but they do typically call back to finish answering some questions that just typically people don't answer in the level of detail that we want. So it can take a little longer that way, but only a day or two usually. I think it's also important to understand that there are other legal resources available that are not through Indiana Legal Services. One really important one is the Indiana Legal Help website, which has forms to initiate most types of court cases that we're going to be talking about: paternity, divorce. There are links to the protective order registry through there. And then there's forms for like just filing something into another case, an existing case, or dealing with other types of issues with money or houses, things like that. So I think it's great to become familiar with the Indiana Legal Help website. And we also have a separate e-filing system for protective orders that's a little more streamlined. Unfortunately slash fortunately, they are rebuilding our e-filing system for the whole state legal system as we speak. And in a couple of months, that is likely to be rolled out. We don't know what it looks like yet because that has not been made public to lawyers and stuff. And I'm sure they're still changing parts of it. I do think there is going to be some separate access for protective orders based on what I've been reading about it. But I'm not sure if it's just going to be a separate link on the same page that will just streamline it a little bit, or if it'll be a separate system, or if they'll end up having it just be part of the regular e-filing. But it should be set up in a way that advocates can create an account that is obviously for filing on behalf of other people. So I think that that will solve one issue that can come up with our current e-filing system, that there's really only one type of account to make. And it also will still allow for regular people to create an account just to file for themselves. So both of those things should still be an option, but we don't know exactly what the e-filing system is going to look like. I also think it's great to be familiar with the satellite attorney program through the Coalition Against Domestic Violence. And there's a few other links here for general website type information about protective order in domestic violence law. So before we jump in, just a reminder, I am sharing information today that is for general use. It's to help you and your clients access this system, to navigate it. It's not going to directly answer any questions about whether to file for protective order, whether to file for divorce, what to say in a legal document. This is information that I'm trying to make available so that people can make their own decisions for themselves. And it's really important for me to do that when I don't have a attorney-client relationship with somebody. And it's also important for everyone else who's not a lawyer to do that, so that people are not relying on you or your understanding of the law to decide for them, that they're getting information and then they're making those decisions on their own. And we want to avoid any issues with unauthorized practice of law, which is where someone is writing documents on behalf of somebody or telling them what their options, what the best option is for the situation, as opposed to what options are available, because there's really no way to fairly and accurately do that unless you're both a licensed lawyer and working for that person in an attorney client relationship. Otherwise, they're unfairly relying on you because you have more expertise and not because you're someone who's you know able to represent them in a legal case.
And as a advocate, social worker, case manager, whatever we're gonna call me today, as someone that works legal adjacent in a multidisciplinary setting, I had 10 years of experience filing protective orders prior to coming to ILS. So I knew some stuff, right? Had some experience, and I had to retrain myself with Williams assistance since we shared an office on the difference between giving like a legal opinion or making a legal reference versus providing some education. And so some of our conversation today will be things that I have learned that are best practices when you're working with clients and filing a protective order to this is how you can ask a question to solicit information in terms of doing this. These are some trauma informed practices that I utilize in working with clients. This is the kind of language that I use. This is how I even start going over protective order. These are the things that I don't ever forget to say when I'm helping a client, whether I'm meeting them in person, over the phone, stuff like that. So that will be towards like the middle of our presentation. That's why this presentation has grown from 1 hour to 2 hours, is because we get into a nice rich discussion about that. William, one of the questions was who created the e-filing system online?
The one that exists right now is a part of the Indiana Supreme Court, and that is a new committee working on the new one that is all like the Indiana Supreme Court is in charge of e-filing. I think it's different from the actual company Tyler that runs the old e-filing system, but I don't know if it's like a different e-filing company or if it is somehow being custom built for us. But it is going to be completely new, and so I don't know if there will be like a specific filing system that existed somewhere else that they're adapting for us or just building a new one. And it is all this stuff is part of the Indiana Supreme Court's responsibilities. So there's like a committee of judges and lawyers and advocates and stuff that do this. One last thing I want to say is that this sort of rule here, I think it is both legally necessary for everyone and also a best practice, because we all know that when you're working with a survivor, the thing you want to be doing is helping them make decisions for themselves. And this is just one more reason that that is a best practice. And I don't think it necessarily requires you to approach things differently. But like always, you want to think about whether someone who's in a difficult situation is coming to you for help navigating the situation, or if they are asking you to give them predictability that you cannot give them, or give them sure answers that you cannot give them, or make a decision for you that's really emotionally overwhelming. And we want to avoid those things as a best practice because it's not survivor centered to do that stuff. But this is just one more reason. So I don't think it requires you to behave differently. It's just one more reason to keep an eye out for a situation where someone says, but real, what should I do? Or, but what is my best option? Or should I file a protective order case? And I think we all have to resist giving that clarity where it's not warranted. One more thing I want to bring up is that Indiana has a law that makes conversations between an advocate and a client who's experienced domestic violence or sexual assault or stalking privileged, meaning that the advocate cannot be forced to speak about it later without the client's permission. There's some exceptions to this, their slide. But if your client is ever tempted to have you go to court with them, you really want to interrogate why they want you to go to court with them, because you would be giving up the privilege to not talk about anything they've disclosed that they might have done that they don't want brought up in court. So it's generally best to get some advice from a lawyer before ever, as an advocate, going and testifying in court. Any of you who work primarily for a prosecutor's office, a police or prosecutor's victim advocate does not have this privilege because you are part of a system that has to share information with defendants in criminal cases. But everyone else who works for a private organization, you have a special right to not reveal information about your clients. This is different from your professional or company policy regarding confidentiality. This is a right that your client has not to have the information they've shared with you be used in court. It is a little more complicated than that, but I'm going to share an outline that has the details of this. And if anyone is ever concerned that privilege is not being respected, for example, if you get subpoenaed to come to court, you should call a lawyer right away. Yeah, and I would recommend calling Carrie Hyatt Bennett if you're one of the organizations overseen by ICADB in any capacity. I would call ICESA if you are one of the organizations overseen by ICESA. And if you are neither of those things, I would recommend calling me or Emily to chat about it. There's also a lot to know about when you have to communicate to DCS or APS. I'm sure most of you have heard of that and when it has to happen and when it does not have to happen. The basic rule, as I would say it, is that if you learn of child abuse or neglect that has not yet been reported to DCS, APS, or the police, you have an obligation to report that to DCS or the police. you should be familiar with your company policies about how to do that in a way that they have determined complies with the law and your client's rights before this ever comes up. So I would very much recommend looking into that and talking to your boss or anyone if you have any concerns about how that's going to work when it comes up, because it does sometimes come up. Okay, so we're now ready to jump into our main topic here today, which is Indiana protective order law. We have a few possible hypothetical questions with some sample answers, like basically a quiz at the end if we have a few minutes at the end. We also want to leave 5 or 10 minutes um for questions. And so I'm gonna shoot for being done by 2:15. We probably will be done by like 2:20. But Emily and I are gonna go back and forth a little bit about protective order law versus what you do as an advocate and what you can expect and help your client prepare for in the process of going through a protective order case. So I'm going to start with the big picture, which is what is a civil protective order? The big picture that I want you to keep in your mind and to emphasize to people that you're working with is that this is a very good tool for providing safety, meaning the physical cessation of violence. It is not a substitute for safety planning and often is not great if you don't do safety planning. It's not a substitute for criminal law. And so it is very possible to do this and also work with the police. It does not include all of the things that can be part of a family law case. And so it's not a substitute for divorce or a paternity or custody case or a child support case. What it is a fairly quick and fairly simple separate legal process to get some court orders to prevent violence that is ongoing or imminent. And if you're not using it for that purpose, it quickly gets less useful. And we'll talk about some of the common ways that it can be misused and therefore less productive to go for a protective order. But I want to focus on that first thing, which is that this is a tool to give you safety from a person who is a danger to you. There are sort of 3 steps, which are usually called elements in lawyer speak, to getting a protective order. You, as the person filing a protective order case, have the responsibility of proving those 3 things. The first is that domestic or family violence has occurred, meaning that some version of the qualifying activities that we're going to talk about here today has happened already in the past. You also have to prove that there's a credible threat to the safety of the person requesting the protective order or their family members. So there's a present situation that you need to be able to explain to the judge as being dangerous. And then you need to explain to the court why what you're asking the judge to do is necessary to keep you safe. That's the 3-step process. And I think that it's helpful to think about it as like you need to explain what has happened in the past. You need to explain that in such a way that the judge understands why there's a present credible threat. And then you need to have thought ahead to what needs to happen to make things safer going forward. I think that especially for people who are going to court unrepresented, it's good to think of this sort of as a storytelling exercise. So you need to hit all 3 of those things. I also think that when you are deciding what to include, there are some important things that just a general story needs to include. So when you are explaining to the judge that not only has violence happened, but it's happened over a long time, it's happened multiple times, and that there is an ongoing situation that creates a threat to you, that requires a lot of context. And so I think that that is something to put up front because typically people lose a lot of context when they file a protective order on their own. They don't say, we've been together for 16 years and it's been violent the whole time. They say, on September 26th, he hit me. And then the judge is left wondering if this is a 2-week problem or a 20-year problem. And so you want to make sure that when you are giving the court information, either as you talk through a story to help someone prepare to testify on their own in court, or as you prepare a safety plan, or as you are drafting a protective order petition with someone, that you are including details that you know about, that they've shared with you in part of their story. So I think that if it's possible to give something of a timeline, you could even have them write a timeline to include as an attachment. We'll talk about the different types of documents you can include later, but you might want to include an incident that says, uh, incident one is an overview, or you do incident one, two, and three are the specific examples, and incident four is an overview of what things have been like during the relationship. Or as they're writing incident one, you could say, on September 26th, there was a violent incident. This happened, this happened, this happened. This type of thing has occurred throughout our 20-year relationship. That way, you've given the context and a timeline without necessarily creating a separate incident. But we're going to talk about the actual drafting. I'm just giving you some examples of what I mean when I say we want to include context. You want to get into the very detailed elements of what happened in the violent incident, because the reason that you are giving more detail than just I would like a protective order in the filing is that this is how the judge decides whether to give a protective order immediately as opposed to after a hearing. And so including the details that help the judge understand all three of those elements are present in this case is necessary if your client is going to get a protective order right away. So the difference between saying there was an incident of violence on September 26th, and here are 4 incidents of violence over the last year, and a little bit of context and explanation and detail. That's the difference between getting and not getting immediate orders for protection that last until you get into court. I think it is also important, even though we don't normally say this in the same sentence or anything, that when we're talking about something bad happening, to highlight where there were direct immediate effects of violence. So for example, you wouldn't normally say he was leaning on my chest, I was having trouble breathing, I was seeing stars, I was having the vision close in around me, I could see that my daughter was crying. You wouldn't normally include those things all in the description of someone, holding you down. But you do want to include all of those facts when you are giving a rundown of a situation to a judge, because not only are you planning to give that story in court, but you do want to give a story that is nearly impossible to fabricate and that tells the judge that you understand what the consequences of this violence were in a way that is digestible to a person who's just reading about it. And the last thing I would include, because this relates to the necessary relief part, what you want the court to do, is to give some idea of what the long-term consequences of the violence have been. So if you've had to leave the home but you want to go back, if you've had to leave the home and you want to stay and you're staying with a relative and you need that address kept secret, those are going to change the way you write about this. If you've had to leave work or change the way you drive to work, or you need car keys back so that they cannot access your car, those are consequences that will help you decide what to ask the judge for. So as you are talking to someone about their story, I would try to, in your head, or even by going over this with them before, think about, we want to include the context, we want to include the specific details of the violence that occurred, we want to include the direct consequences of that violence, and we want to include the long-term effects of experiencing the violence so that we can hit all three of these elements and we can make a really strong case for an ex parte protective order. Now I'm going to talk a little bit more about the very specifics of this law, but I'm going to encourage you all to probably do most of this reading later. A protective order, as the thing that we call a protective order, is created by the Indiana Civil Protection Order Act, which is a separate law from all other previous versions of this sort of thing. In order to keep someone safe from violence, it's been part of the law for a very long time, but it was usually something that was done informally as part of another court case. We are all probably familiar with a criminal no contact order, or have heard of what they used to do in divorce cases, which was sort of like a mutual restraining order or something like that. Police would often make up a thing called a peace order or a trespass order, even where those things are not really legally applicable because no one is trespassing, or in the historic situation where you would have like a peace bond or something like that. There's just been a lot of informal ways of doing this. And in the early 2000s, most of the states passed a much more formal version of this, which is what we have now in this protective order law. The purpose of it is to protect people from violence, stalking, harassment, sex crimes, and to protect children from people preparing them for sexual activity. It is supposed to create a fair, prompt, and effective process. So it is intended to be more accessible than the other types of help that are available, like police help and those sort of informal things that are available in relation to other cases. It is supposed to be totally separate and in addition to and not instead of other types of court cases. So it is supposed to help you solve this problem without getting in the way of any of your other legal tools that you have available to you. It is compatible with other criminal and civil cases, meaning that a protective order can be modified to include, well, you both go to a parent teacher conference, but it's only for that very specific purpose, and you cannot talk to each other, and you cannot, be in the same place longer than necessary or something like that. A protective order is very flexible in that way. And also, when there's a family law case that has orders for custody or control of property or something like that, those orders automatically supersede the protective order, meaning that if you have a protective order and you have a divorce case that says, my kids are going to have parenting time with their dad on Wednesday from 3 to 6, that means that the protective order has to give way to that kids having parenting time from 3 to 6 on Wednesdays. That can cause some problems because there's a lot of times where maybe DCS says we don't want you to allow parenting time. Get a protective order, even though that doesn't work that way. But I think just getting to a hearing where all these issues can be sort of hashed out is usually the best solution to that. And in the meantime, it's really important to know that you don't need to drop a protective order because there's a criminal case, because there is a family law case, because your kids need to be exchanged between you. A protective order can always include exceptions or be modified as needed to be compatible with other court orders. A protective order is very special among civil cases in that you can enforce court orders generally by contempt, where you go file and say this person's violating a court order, and the judge will decide if there's some money they need to pay or punish them by modifying the order or extending the order, or in a very extreme circumstance, contempt can involve jail time. But that's not the only way to address violations of a protective order, because we have a special law that makes it a crime to violate a protective order after the person knows about it. So I would always recommend that as the first way of enforcing a protective order, to go to the police, report a violation of a protective order, and try to get criminal charges for invasion of privacy. And if that doesn't work, it is totally fine to file for contempt also, but I would recommend the version where the government helps you enforce it first. And we don't need to go into this, but there can be some issues if you do one and then the other. So I would do the criminal one first. So any adult can file a protective order if they are the victim of the violence, or if their child or a person in a similar relationship to them, a parent, guardian, or other representative, can file a petition on behalf of the child. Children cannot file protective orders for themselves. And I would just bring up again that where there are court orders for custody and parenting time and stuff, protective order is not going to change those things. So it's best to involve those courts as well if you're ever dealing with a protective order involving children and parenting time. But there's no minimum amount of time you have to be in Indiana. There's no limit to who can file for a protective order as long as they are in Indiana, the violence occurred in Indiana, or the respondent, the person they're filing the case against, is in Indiana. And that's similarly, you can file in whatever county you want, as long as it's the county where you live, where the other person lives, or where the violence occurred. However, if there's a divorce case or a DCS case or another family law case, you should file in the county where that already is, so that the same judge can be in control of the case. And they will usually transfer the case before doing anything if you get that wrong. So it's not very harmful, but it does cause a delay. So there are some specific bases for a protective order in Indiana. And I don't think we need to read through these definitions word for word, but I do want to give you some general strategies for how to decide what to put. So I am including with the materials here the specific definitions of the types of violence that qualify. I would show that document to anyone who you are helping to decide, because otherwise you're going to say domestic or family violence, sexual assault or sex crimes, stalking or harassment. And a lot of people will put harassment or stalking because they're pretty broad. Some version of domestic or family violence or a sex crime could apply as well. And so I would encourage people that they can check more than one box if they apply to their case. There's no downside to checking multiple boxes where they all apply. Read through the definitions with them. If you think they're not in a position to read a 2-page document, that's fine. Just say we can check all these that apply. Here are the definitions of domestic or family violence. Here's the definition of a sex crime. Here's the definition of stalking. Here's the definition of harassment. And I would read them in that order because we're going to talk a little bit about what the limitations of different ones of these are. So when you have domestic or family violence as an option, it should probably be your option because it's very broad. Don't want to skip ahead. We talked about this a little bit before, but when you're writing the petition, you want to make sure that you are proving that there is a credible threat to their safety by including all the background information necessary to make that connection. And then when you are going through the last part of the petition asking for what specific court orders you need, we're going to talk a little more about that in detail, but you want to make sure that you've kind of covered those items. So if you're saying I want him to surrender his guns, we want to have a list of the guns. We want to maybe mention any incidents involving the guns. If we want to get a set of car keys back, we want to make sure we mention he takes the car keys away. He hides the spare set of car keys. He's gotten into the car without their permission. They need the car to get to work and they're worried he's going to take it or he's going to get in the car and use it to interfere with them. So that when you get to that last part, you're going to want to think about what things are we asking for and have we talked about why those things are necessary in the description of what's happened so far. So here's the main definition I think everyone needs to know. Domestic or family violence is when a family or household member attempts, threatens, or places a family member in fear of physical harm, causes them to engage in involuntary sexual activity by force, threat of force, or duress, or beats, tortures, mutilates, or kills a vertebrate animal without justification to intimidate that person. So that is a very broad category of things, because if you place someone in fear of harm, many people do not think of that conduct as domestic violence. If you just say, has there been domestic violence? Most of the people I have worked with will omit, well, he stood over me while I was at the kitchen table, so I couldn't get up and he took my phone away so I couldn't call for help. And he made me feel like I was the aggressor when I bumped into him trying to leave the room. And he would, stand outside the bedroom talking to me when I was trying to go to sleep. Those types of things can place someone in fear of harm. We all know in examples of things that have happened like that they are conditioned to not think of as domestic violence. They think of placing your hands on someone else as a necessary part of domestic violence. And attempting by smashing something, threatening by saying, you better not, do what I don't want you to do, smashing items to make someone be afraid, or actual physical violence. Those are all things that can qualify, and I would not skimp over this description of what this means when you're reading it to somebody, because you want to make sure they're thinking about, are there times that you've been afraid? What was he doing that made you afraid? Has he ever made you think that he was going to hurt you? Has he ever put hands on you in a way that made you think that it was going to hurt, even if it didn't at the time? Those types of conduct can be very familiar for a judge who's heard about a lot of violent situations. Coerced sexual activity as opposed to forcible sexual activity is not something everyone thinks about as rape. We want to make sure that when we're asking questions about this, we're giving people the leeway to have different cultural or societal definitions of what these types of crimes are, because most people have a skewed opinion, especially when someone has been spending time to make them think that they're not the victim in the situation where they clearly are. It can be tough when someone doesn't have a very clearly defined relationship with somebody to include them as a family or household member, but it does include anyone in a current or former dating or sexual relationship. So if there's ever been a consenting sexual relationship, I would include domestic or family violence as an option, pretty much no matter what the other things are that you're going to include. So if there's a sexual assault, but there was ever a date, I would include domestic or family violence. If there is a sexual assault and they are related, no matter how distantly related, I would include domestic or family violence as a basis for it, because that makes anything else that they were doing, like calling them and telling them not to go to the police, a potential other incident that you can mention. There is sometimes a bit of an issue because this includes like children of these types of relationships, but it doesn't include adults who have this kind of relationship. Oh, I didn't include it written out, but it excludes like two people who are just roommates. So if you have a roommate you've never been in a dating or sexual relationship with, and there is a sexual assault, that makes a sex crime the only basis for your protective order unless there's like subsequent stalking or something like that. We'll talk about stalking in a little bit. Or if it's you live in your parents' house, but you are an adult and their friend or partner or something like that does something wrong, you don't really have this family or household member relationship as it's defined here. And so you want to think about, is there a way to define this as a family or household member relationship? Because it opens up such a broader definition of qualifying violence. But there are three other bases for protective order. So the second one is sex crimes. Those are defined in a specific part of the Indiana law. I'm going to include them. It includes rape, sexual battery, sex crimes against children, and I doubt this would be treated as a violation of as something that would qualify for a protective order. But violations of restrictions on sex offenders are in there. I don't think that you could get a protective order against someone just for living too close to you when they are a convicted sex offender, but they are technically in the chapter. They do not have to be arrested, charged, or convicted of any of these crimes for that to be the basis of a protective order. Remember, this is a totally separate civil case. It's just using the definition of those things for whether this is a qualifying action to justify a protective order. You don't have to have talked to the police, done a rape kit, or cooperated with the subsequent investigation. You don't even have to have talked to anyone about it. Many people think that a protective order case is somehow related to criminal law. It is not at all related to criminal law, except for the fact that you can file a police report for violating one. And so that will be a common misperception that you will frequently run into, that well, they'll say, well, I didn't tell anyone. Well, I don't have any evidence. Well, your testimony is evidence and you can tell the court about it. And that is enough. That might change whether you decide it's worthwhile to go through the stress of filing a protective order case if it's not something that has come up more than once, or it's not something that is an ongoing safety problem. But that's a totally different question from whether you have to have multiple avenues of proving something or need other types of evidence to prove something. Our next one is stalking, which sounds very specific, but is not at all specific. So this definition is very broad. It does not need to be any specific relationship. It can be a total stranger. It can be a neighbor. We actually have kind of an ongoing problem that we're trying to figure out, where you don't always know the address of the person, and some clerks will not accept a case where you don't know the address of the respondent. And so we need to try to figure out what to do about that. But you know, you sometimes are being stalked by someone who you don't know their address. But it doesn't have to be like traditional criminal stalking, the way people think about it in like pop culture, but it is just repeated or continuing harassment of another person that would cause any reasonable person. So the reasonable person is a legal term, meaning would I, if I were in your shoes, feel terrorized, frightened, intimidated, or threatened? And it actually causes them to feel that way. So not only do you, in your own experience, feel afraid, but is it reasonable for you to be afraid based on what you know? I don't think that that's that much of a barrier for everyone, but it is something to think about, that when you are giving more context, you are helping the judge understand why your fear is reasonable. So if you're giving three or four examples as opposed to one or two examples, if you're explaining, well, the reason it scared me that he left a note on my car is that I specifically told him not to do that. I specifically told him not to talk to me anymore. He didn't know where I worked. He didn't know what my car looked like. So if you give context to helping the judge understand what is reasonable, you are helping prove that stalking has happened. And I would say this applies as well to the placing you in fear of harm. It doesn't require that it be reasonable to be placed in fear of harm, but I do think that the judge would likely be helped by explaining why it's reasonable to be afraid. Harassment, as defined in this long definition, is conduct that includes but is not limited to repeated or continuing impermissible contact that would cause them to suffer emotional distress and that actually causes them to suffer emotional distress. So this is a way overdone definition that includes that reasonable person twice for some reason. But I think it's important to just understand it does not have to be showing up at your work. It does not have to be standing outside your house. It doesn't have to be driving by. It can be exclusively text messages where you make very scary threats. It can be exclusively social media posts where you're like doxing somebody, but repeatedly, clearly having an issue where you are a threat to their safety. But it doesn't have to be following them around. It doesn't have to be communications in writing. It doesn't have to be social media. That is a non-exclusive list of things that are obviously potential harassment. It is not stalking or harassment to simply talk to someone too much. So you have to prove that fear element, that you are reasonably and actually afraid, in order to prove stalking. Otherwise, you have a First Amendment problem where people are not allowed to bother their neighbors or have disagreements with people or not get along with their classmates. And so we want to be talking about a situation where you are reasonably actually afraid of multiple incidents where something has happened. And again, they have to be a danger to your safety to get a protective order. That second part is still applies in a stalking case. So you have to be showing that there something dangerous is more likely than not to happen. Harassment is defined exactly the same way. There's a separate repeated acts of harassment basis for a protective order. This was added sort of pointlessly because someone wanted to include bullying in the protective order law. And it got watered down to the exact same type of harassment that was the part of the definition of stalking, except if you only choose harassment, you cannot get an immediate emergency ex parte protective order. So when you file a protective order and you only say harassment, you are not going to get a protective order until you have court. That is not true of stalking, sex crimes, or domestic or family violence. So really, really important to do these in this order, to say, was there domestic or family violence? Was there stalking or a sex crime? And then only if you truly don't think there was stalking, which is exactly the same thing. So tough to understand how that could be possible. You would check repeated acts of harassment. And there is one last way to get a protective order. If you are filing on behalf of a child under 18 and someone has been engaging in contact that is intended to prepare or condition the child for sexual activity. I think I've been calling this one grooming, except that became a very politicized term in the last few years. So I always want to emphasize this is a defined term. It's not, I think you're grooming somebody for whatever thing. It's if you are talking to a child in a way that is intended to condition them to engage in sexual activity, there is a defined crime that I'm going to include in the outline I'll send you that you want to look at before you apply this definition. I think it's in the short list of definitions I included as well. If they're over 14, this does not apply in criminal law. So I don't think it would probably be applied in a protective order case if the child is over 14. And sexual activity does not mean exclusively sexual intercourse. It also includes what I think you would call sexual battery, just like touching and things like that. It does not have to be like someone talking about sex. It can be someone maybe conditioning a child for sex. I also think that when you are dealing with this type of situation, I get very concerned about parents handling what could be construed as child porn. If something is potentially pornographic and involves a minor child, that is like a FBI level problem for any adult to be handling it, making copies of it, sending it to anyone else. And so if you as an advocate end up with somebody on their phone showing you a picture of a minor child who's naked in a sexual way, who's engaging in any type of sexual activity, I think you want to be going the DCS route pretty quickly, and you want to make sure people understand that they should not make copies of. Probably they shouldn't delete those things because that probably needs to go to the police rather than be deleted, but they should not make copies of it or send it to anyone else except for when they're instructed by the police, because that's a very, very serious federal crime to make copies of anything like that. And I understand that we really don't want to get kids in trouble for doing things that they might have done themselves, especially if it's with other children. But if it's at the level where the parent is concerned about their safety, I don't think it's at that level anymore, right? You are not going to get told about something. Yeah. So Mallory asks, will I explain what I said about over 14 years old? So if the child who's being groomed is over 14, this crime that is defined as like preparing a child for sexual activity is not chargeable. Like that, the crime includes that you're talking about a child under 13. I think that's because child molestation in Indiana is defined as sexual activity with a child under 13. And then there's some separate, I don't know what it's called, like sexual activity with a minor or something like that when they are 14 or 15. And then I think Indiana's age of consent is actually 16. So there wouldn't be a crime for sexual activity over age 16. But I would probably consider this appropriate to consider filing if there is like a child porn situation for an older child, because that just wouldn't be something that the police wouldn't get involved with. Like, that is definitely a crime. The thing is that if you're in a situation where the police should be filing criminal charges, you probably don't need a protective order unless this is a parent. And then you should be engaging with the family court. So the situation I am imagining is adult perpetrator, child under 13. That is clearly what this law, the criminal law, is about. When you get adult or minor perpetrator, child over 13, don't know how this would be applied in a protective order case because it's not used very often, and the criminal law doesn't include that type of situation. I don't think it says the perpetrator has to be an adult. So if it's a 17-year-old and a 13-year-old, or a 16-year-old and a 13-year-old, I think that's potentially still something you could file a protective order about. But again, this is probably going to be get a lawyer territory here, and probably talk to the police territory here if it's something where you're concerned that your child is being groomed for child molestation.
You guys have some good criminal law questions. There was one in the chat, William.
I don't know why DV in front of a minor under 16 is a thing. I think it's probably just that they're sort of assuming that children under 16 don't have as much ability to get help or to flee a violent situation. But yeah, there is a felony enhancement for DV in front of a minor is up to age 15. I don't know why that is. So the last really important thing about how the law works in protective order cases is that this is not a criminal case, meaning that people are usually thinking about, how do I prove this to the point where a judge will believe it? And these definitions that I've been talking about are largely taken from criminal cases. The criminal law, the domestic or family violence is not, but this is a civil court case, meaning that when you are trying to get a protective order, for three responsibilities are proving the violence occurred, there's a credible threat, and that you need the orders you're asking for. But you only need to prove those by what's called a preponderance of the evidence, meaning that it's more likely than not. So 51% or 50% plus anything. So it is more likely than not that the violence occurred. It is more likely than not that they're a threat to your safety at the time you have court, and is more likely than not that the relief you are asking for is going to be necessary to keep you safe. So I need him out of my house. More likely than not, it would be bad for him to be in my house. I need my car keys. More likely than not, it would be bad for him to be accessing my vehicle. That is a much, much lower burden than criminal law, which I've heard described between 90 and 99% sure that something happened. It is very different. It is hard to describe how different it is for a judge, because a judge is not going to tell you how easy this type of decision is, but they will certainly not be applying the same level of scrutiny that they would if this was a criminal domestic battery case, for example. There's a few things that can happen when you file. We're going to talk a little more about that after Emily explains the process of filing. But I really want to remind everyone again, they do not have to report anything to police to get a protective order. They do not have to have gotten an arrest, a criminal charge, or a conviction to get a protective order. And you don't really have any reason to bring that up in the protective order case unless they pled guilty. And that's sort of a fact that just is true. Like, so if they've pled guilty or been convicted, that's something they can't really dispute later. But if they never called the police, it's not really evidence that it didn't happen. It's just evidence that no one went to jail for it. So it does not matter if you did not call the police or they were not charged or convicted. If the court just says no when you file the case and doesn't set a hearing in court, the case is dismissed. But this is what's called a dismissal without prejudice. So you can usually refile with more details or any new incidents without any kind of issue. You can also request a hearing as a petitioner if the court just doesn't do anything with your petition when you file the case. If you think that maybe I don't need an ex parte order right this second, I want to get going with this case, I want to get a hearing, I think I have more evidence than what I included in my description to the judge, it's totally fine to just request a hearing in the same case. If you feel like an ex parte order is necessary, you can either file an amended petition where you take the same exact form, write amended, and include more details or any new information, and request a hearing. You can file a request for a hearing. They have a form for that for the respondent that you could probably just like mark up for the petitioner, or you could just file the amended petition and ask for a hearing in more clearly in that form. There is a situation where you can't refile protective order case, and that's where you go to court. There is a hearing, and the judge decides you don't have enough evidence to get a protective order or you are not in danger right now. And that means that if that happens, you would need new evidence from after that hearing. So we had two incidents that were basically stalking, but that the judge didn't think that you were in danger yet. Well, incidents 3 and 4 might change that balance for the judge. You could file a new case, mention incidents 1 through 4, and hopefully that's enough evidence to get a protective order. The only thing you can't do is just say, well, I'm going to just file the same exact petition again. And hopefully they'll agree with me this time. You can't do that after you've had a trial essentially and had your petition denied. You could refile the case if you dismiss it voluntarily before the hearing or you fail to appear for court. I would obviously do everything you can to avoid those things happening if you still need a protective order. And it's not 100% clear what the judge would do in those cases because the respondent may have gone to court and had an opportunity to go. And if you dismiss a protective order after you got it at a hearing, that's probably a final decision too. And there would need to be some new evidence to refile the case. So before we jump into it, the resources that you need to know about are the Protective Order Desk Book, which is a description for judges about how this process works. I think that gets pretty into the weeds, but I would at least skim that at some point. And then the form bank that goes along with that, which is Word and PDF versions of all of the forms that are generated by the PO system, and then a few others like the ones to file to request a hearing or to dismiss a case that would only come up if the petitioner or respondent wanted to file something. It includes the actual petition form. So if you wanted to file an amended petition, that form bank has the petition form and they could just write amended petition. On that, I have in a couple different places, though not on this exact page, the e-filing service provider for protective order cases. It's separate from Indiana's e-filing system right now. It may become merged with it later, but it's going to generate 4 forms for you when you fill out everything. You want to make sure the client is reviewing them. When possible, that they are typing the signature themselves. Really would never do it unless there's no other way for them to, maybe write down in an email, please sign my name for me on this thing, because there is a place where you are signing under oath that everything in the petition is true. And that should be done by the person who's it's basically an affidavit, who's signing the affidavit. So it should generate a petition. It should generate a cover sheet, which is a confidential form that includes certain extra information for the police. It should generate a notice of exclusion form that you really don't need to deal with. It tells the court that the cover sheet is confidential and shouldn't be posted online anywhere. And then the appearance, which gives their contact information and a list of the other court cases involving the family. That is really important for the court to know about, so they assign you to the right court. Make sure they are reviewing that. Make sure they are signing that in any situation you can. I included here because it didn't really fit in anywhere else, but there's only one petitioner and one respondent in each protective order case. That means that you do not have a situation where you file a protective order and you list your children as family members and they are protected to the same level as you. You are the petitioner who's being protected in the protective order. There are some things that apply to family or household members. We can talk about that if people have questions about the family or household members. And it is possible to file like 4 protective order cases for the person who needs protection and all of their children against the same respondent. I would just be questioning at that point whether it is probably more of a parenting time issue. If the children are the direct victims of violence, I think it is always appropriate to file a protective order case on behalf of a child. If your concerns are less safety of the children and more parenting time issues about the children, that sort of becomes a family law issue and you want to emphasize the safety aspect. You obviously can't tell someone not to file a protective order case for their kid, but you might want to consider whether that is really what they're going for. And also, if there are multiple people you need a protective order against, that's multiple cases. So if it's my neighbors, Jack and Jill, are, throwing shit at my car every morning while I'm getting in the car, I have to file a case against Jack. I have to file a case against Jill. Fortunately, my neighbors don't do that. So let's hand off to Emily for a little bit to talk about what it looks like to file a protective order right now. We're not going to have this exact screen anymore pretty soon, but this is just going to help us go through the process of actually filing the protective order. So I'm going to skip the beginning because the login and all that stuff is going to probably be different by the end of this year. And you're going to start with choosing a county, which, like I said, it depends on if there is an existing case, if you live there, if the other person lives there, or the violence occurred there. You can choose the county, or you are kind of stuck in your county if you have a divorce case. Emily, do you want to take over?
Yes. The way that I'm going to kind of do this is kind of set the scene of we have a survivor that comes in, and whether it's in person, over the phone, you have to talk to a client about the most important thing that our job and role, attorney, helper profession, whatever role you're in, is always safety planning. We're always going to file a protective order with the idea are we increasing the safety of this client? Because a protective order is not necessarily the right remedy for every client in every situation. I know we're doing a training on protective orders, but after 16 years, a protective order isn't the right call in every situation for every client. And remembering that that call is the client's call is what's most important. We, as people that have experiences, it's really natural for us when we're working with a client, building a rapport with a client, empathizing with a client, starting to ask them questions, getting to know them, that we draw upon our own experiences and we kind of insert how situations have worked out in the past, whether it's previous client experiences or whether it's our own personal experiences, and guiding our practice. And so, one thing that's really good to understand is when we're doing a protective order, since it's supposed to be pro se friendly, the document itself is a template. It's a guide for us of how we can talk to a client. And again, when we don't want to be the people that provide legal advice. We don't want to say, well, based on my experience, this is what I would do. That's making a legal conclusion. And again, if you're like nervous about how I'm saying this kind of stuff, it's you can always reach out to us and ask us questions. William really got in the weeds with some very, very specific protective order complicated stuff. And so when we're talking maybe not the run of the mill or the very straightforward protective order cases, if you have questions about petitions for on behalf of minors, if you have questions in regards to the grooming or the stalking or sexual assault related petitions, those are harder. Stalking petitions are harder. I've had a petition before where a stalking petition, here's an example, where it was over 300 pages long, the petition with evidence, and it was over a 10-year period. And this is someone who she had lived in a different state, but flew to Indiana for me to help her with a protective order because this is someone that she met this is someone she was in second grade with, who just started stalking her when Facebook came out and was a thing. And everyone was friending everyone, right? So when a client comes in, we want to, sometimes we have like a longer interaction with them. Sometimes we kind of have to like get in, get out. And so, what some things I'm going to talk about are some of the non negotiables of when I'm working with the client. When we're talking about the protective order, again, we want to inform the client of the protective order process. Like, this is what this is like. And it's a little bit different for everyone, but we know that this could be set for a hearing. We know that there's a line in the protective order that says anything you check after this is going to automatically be set for a hearing. We want to remind clients of that. We also want to remind them that the respondent, the person we're filing against, has the right to request a hearing, due process, right? So if a client is not prepared to go to court and is not prepared to testify, it's really important that we mention that there is a chance that you could go to court. And there are a lot of cases and situations, especially, it's not just Marion County, but all these outlying counties. We've got people up in Northwest Indiana on this call, all throughout the state. All of these courts work a little bit differently. You, the person in your county, likely know how that court's operating. If something feels funny or fishy or that doesn't seem right, of how that was just dismissed without a hearing or someone didn't get to testify. Those are the types of things that you also can reach out to us about at ILS. Or if you have to file an amended petition or one of these, like an extension request and a protective order, and you're like, okay, I've never done these forms. This is where a client can come and do an application with us. If you send me questions in a situation, oftentimes I'll have community partners do that, and I'll say, okay, they need to have an application done because we've gotten into the legal territory of things. And so it's really important as you're gathering information that we let the clients know that this is a possibility. And whatever we put in this protective order, they could possibly testify on. So sometimes I find that sometimes clients are really uncomfortable with testifying about sexual assault incidents. Now, if the basis of the PO is just sexual assault, this is a harder conversation. This is a harder protective order to navigate. Some best practices around when we are working with clients is to use their language and not our language. So we're trained on what that choking means is strangulation. But we want to use what the client is stating. On this date, this was going on, and they use their arm to like hold me down. I'm talking about a recent case that I have where they pushed up on my neck and my started to choke and I couldn't breathe. So again, we want to use the client's language. We want to cover kind of the basis of, okay, this is what you're here for today. Okay, these are the safety concerns. And if we've identified and the client's identified that I need a protective order for my safety, then we start to move forward. But that safety planning conversation is, I want to stress, is the most important start in these conversations. What kind of abuse is happening? Is it protective order stated? Where is it, they've caused physical harm? Did they place me in fear of physical harm? Have they committed an act against of animal cruelty with the intent of this? One thing I do is I read the protective order to clients. So I read those statements out. And sometimes when I'm doing this, before I check off these boxes that you see on this initial page, the ones where it says, I am or have been a victim of repeated acts of harassment, of domestic violence, I get into the narratives first, and then I go back and check these off. I also recommend having a Word document open where you can save as you're going along. This is just something I've learned because sometimes things crash or your computer shuts down and you have lost some of the work that you've done. You can pause in these types of things. And so what I say is, hey, when we're filing this protective order, I'm going to read these off to you. Whatever we check off here, we want to have a corresponding incident. We want to show and demonstrate that these things, these legal definitions here, the respondent has committed. Sometimes in protective orders, we can get check happy. So if you have a client that you hand the PO to and they check everything off, this is where you can come into play and help them, guide them checking it off. Because what if they filed a protective order on domestic interfamily violence and they didn't request any remedies, but they checked harassment? It's automatically going to be set for a hearing because they checked harassment. And so we want to make sure, I think that's great. Having clients write out the incidents is fabulous, and you can help guide them and saying, let's get maybe a little bit more specific here. So I'm going to ask a couple of like guiding questions.
Emily,
Uh,
to your point about like the order that these check boxes go in the form, it's like the sixth or seventh page where they actually asked, did they attempt to cause harm, threaten to cause harm, cause physical harm, or place you in fear of physical harm, causing you engage in involuntary sexual activity, etc. Those are like 6 pages after you had to decide if they committed domestic violence, if they committed repeated acts of harassment. And those are just the definitions of those terms. And so there are two sets of checkboxes in two different locations that mean the same thing. And if you start like Emily's saying with what has happened that makes you want a protective order, and then maybe show them this broken out list, see if there are more boxes they're checking than what they've covered in their story, then you can back up and say which of these actually applies to them. And I think that this is like we've been talking about, one of the most common issues is that this is the first thing on the form. And so people are just checking off based on their general understanding of which of these applies to their case without any idea of what they mean to the court and without having thought about which stories they're comfortable telling first. And
Remember,
yeah,
yeah, this person is super overwhelmed. This person is coming to you likely in a crisis. And so you are the eye of the storm. You are the calm in the helping a client navigate through this process. This will help. And the reason this is how I do it, everyone's going to kind of develop their own shorthand if they haven't already on how they do a protective order. But I like my clients to be informed up front, like, hey, let's kind of this is where I'm going to ask that lovely open-ended question. Tell me why you want to get a protective order. What has recently gone on? And when you're drafting these narratives, you can do it in William talked about this a little bit earlier. I personally start from the most recent incident and work my way backwards to show the history, but you can also do it where you start with the first incident and work your way. You can start with the first incident that occurred to the oldest. I think I just said that twice, but meant you can do it either in reverse. You want to do it chronologically, though. That's the best way. And if a client doesn't know the exact date of an incident, that's totally okay. This is where you can ask prompt questions. Was it warm? Was it cold? Was it after a holiday? Can you recall if it was? What year was it? Was there an anniversary? Was there something that happened? And oftentimes they can kind of start recalling because we're asking a crisis brain when we're talking about the neurobiology of trauma. The way that this happens is clients when they're being assaulted or when something's happening or when you're placed in fear, your memory is going to store a little bit differently than if you were telling a story like Goldilocks and the Three Bears. It's going to be, oh, I remember this very specific fact. When William mentioned heard my kid crying. Sensory storage of protective order information is going to be key in asking questions. How did you feel? Did this hurt? Which may sound like a stupid question. Yes, someone punching me with their fist closed hurt. But helping a client to acknowledge pain that they felt and what it felt like and what that incident made them feel. Did it place them in fear for their life? In fear for the safety of their children. Those are important things when we're talking about what was the effect of the repeated acts of abuse or the one act of abuse, whichever you're checking off. It's really important for us to show the judge why these things have been a detriment to my safety because it helps establish that thing that William said. Is this a person that's a credible threat to my safety? And so that detail, again, we're not writing it, but asking prompt questions to help stimulate the conversation, because sometimes you're going to get a client that's yes, no, yes, no, yes, no. And that's okay. That usually means that it's harder for a client to recall information. It's also just harder for them to talk about it. And this is where you asking yes or no questions will help guide that client. So you may be typing up this for a client because maybe not all clients can write out a narrative. I kind of allow a client to guide how they want that part of the PO to go. Um, and if I can type things up, like send it to them and say, can you check over this? Can you add detail? Or I always, if it's over the phone, I go back and I read the entire incident. And if I am reading the incident, I'm like, oh, I can ask a question here that says, how did this make you feel when you were cornered in a room? And
I also think, Emily, that when you ask those types of questions multiple ways, like you're talking about, where it's like, how did that feel? Did that hurt? It can open up things that, like, the easy path through the story in their brain is often a very narrow one because it's about survival. But if you're like, your arm hurt, did you have a bruise? And they might, because they're no longer in trauma mode, have way more detail about that bruise from over the month that they lived with it then they were immediately able to recall about getting the bruise, and then they'll be able to
Mhm.
look backwards and tell you exactly how they got that bruise. So, you know, you said I see you have a mark on your arm in this picture you're showing me. When did you take that picture? When did the bruise go away? How soon after was that? And they might be able to launch into a really detailed story about, This was about
Absolutely.
48 hours later. This was the next morning. And then they might be able to go back to, yeah, he was gripping my arm. That's when he knocked me down. And you'll get more details that were not part of the we're going through the story chronologically version of the story, because that's a really tough thing to talk about. But they might be able to come back to it using details that they had from after they were in the traumatic situation. There was one more thing I wanted to add. It's really tempting because this form asks for so much information to interrupt to try to fill out the form. I think that there's a tactic that you want to probably try to use. I think that writing it separately on a separate Word document somewhere is probably the best way to start, because you're not tempted to say like, okay, but like what day was this? Like that is not possible while they're in the middle of telling the story, like Emily was saying. So you probably want to wait until the end of telling the version of the story that they're able to give you up front to say the stuff about when was this. Trying to piece that together is very distracting from them telling their story. And so taking the notes somewhere else, writing it the way the client wants to write it, like Emily's saying, and then filling in the information that the form is asking for last, after they've had a chance to speak. And I think that's just a best practice, that you don't want to interrupt several times while someone's telling a story. You want to write your follow-up questions maybe off to the side somewhere. And I've seen lawyers who do like interviews of people in a traumatic situation to prepare for like a first hearing. They'll have a left side, which is what the client said, and they'll draw a line down the middle of the notepad. And on the right side, they'll write questions that they have for the end of the client's story. And that way you're not interrupting, you're getting the information you need, but you're not stopping them from speaking when they need to speak. And you're forming a rapport. You're listening, you're actively engaged, but you're not getting in the way of them just telling their story. Emily, is there anything you want me to say, or you want to say about the respondent part? That I think someone said that they have a challenge with this, just like including enough information to get the case filed.
I'm not done talking about the other part though.
Okay, let's go to the incident. Let's go back to the incident.
This is the most important part, in my opinion, besides like the logistics or the nuts and bolts of filling out the form. So in addition to what William said, it's okay to interrupt if you're asking like a clarifying question, in my opinion. So if you are having because a lot of times we'll have an incident when there's physical violence, you might be moving from room to room, and so you might have to ask, okay, where were you at, and you were in what position, and they were where in the room, and figuring out the location and what's going on, also indicating in terms of when you do sustain an injury, if the client can recall if they were hit in the left arm, right arm, head, fist closed open, if there was an object involved, a gun, a knife, a chair, a something, and if it made contact, all of that information indicating injury is important in every incident. If it's a client that's just coming out of the blue, things I'm asked, do you have any documentation of that? Did you take any pictures? Can you please send those to me? And then asking questions about the pictures. If I know that a client called the police, the things that I ask are, do you have a copy of the police report? And have them send me the number and include that at the bottom. At the end of those narratives, I will ask if they had medical attention, if they sought medical attention, and if photos were taken of the scene. And that's something I include at the end of those narratives. Client called the police, spoke with, police report taken. They'll send like a picture of like the number that you get for the incident report. And if I'm not sure if a client called the police, I'll just say, you called the police. But I make sure to preface when William said that some people realize that they can't file protective orders because they have never called the police, or they don't have evidence of it, or maybe the evidence was destroyed. A client's testimony is evidence, like he was talking about. Testifying, just because a person didn't go to jail or wasn't convicted doesn't mean it didn't happen. So I think it's important to remind clients it's totally okay that you didn't report. We understand that it's really scary to report. And that's where we as advocates want to reserve any judgment of like, well, why didn't you report this? I would never ask my client that question. I would just say, okay, you didn't report. That's totally okay. And there's a lot of fear, shame, and guilt around that. And so I think it's important to validate a client in that experience. Also, in the incident, if they can't remember the date, I will always usually say, I love this, like floating heart. I didn't know this is something you could do. It's important that if it's the exact date, I will always start my petition on July 5th, 2025. Was you give a little bit before the incident, like what was going on before, because usually it's not like you punch someone. Usually it's like we started arguing about, I had a client yesterday. We were arguing about he didn't make coffee. This resulted in a strangulation and a police call with several defensive wounds on the client. So it got very packed, but we gave a little bit of the narrative before and then the results of the police being called afterward in this. Not all incidents are super explosive like that. And so we want to, when we're asking those questions, has this ever occurred? Has this ever occurred? When we're reading off those definitions and a client says no, yes, then we start asking those questions related. Okay, well, tell me about the most recent incident. If it's not a specific, you can say on or about March of 2022, even 2022, if they can't remember the time of year, or summer of 2022 is an example of what you can put. If you're getting text messages or or it's all over the phone, in terms of the address, I put the address of where I read that text message. So if it's my home address, I'm putting my home address. In addition to the narrative, William made a really good point, like the overview. This is one of my favorite things in training in regards to a protective order petition. We often know that our clients that are experiencing any of these types of violence, it's not the first time. When I'm talking about a client telling me a story and they're like, this has happened so many times, like I don't, like I can't even count how many times it's happened. I'm like, okay, really good sentence for me to include in the petition. But the way that I will talk about this is, okay, can you tell me about the most recent incident where that type of violence occurred? And then at the end of the incident, I will write a sentence that this has been happening since. And then if the client indicates, oh, this has been going on for 8 years, I will count back 8 years and say, okay, so you think it's about 8 years? I will write an incident. This has occurred so many times over the last 8 years that I report every single incident. I will put something that establishes pattern and duration of time that this kind of incident, because we're going to have people that have so many incidents that they can't recall. Judges usually want to see the most recent. They want to see that this person is a recent credible threat to safety. And we want to establish patterns. We want to establish if children were present, if anyone at all is present, someone that could potentially be a witness or testify to it. So when we're talking about protective orders, those are some of just like the key things that are really important in starting the protective order, getting the narratives. And after I get the narratives, after I figure out if there's evidence to attach to it, after I figure out what to check off, that's when I go through the entire protective order and check the different things off with the client. So William, if you want to go back to that first page.
Yeah.
I also think it's important to remember matching client language. In sexual assault petitions, it's really important not to say rape. If a client if they're talking to you, you wouldn't say, oh, so you've been raped. Use the client language. If they say, well, they sexually assaulted me, and you will ask permission and consent, because remember, consent and permission were taken away from the client. You can ask for permission and consent 85 times in a conversation. And you're giving that client a little bit of power back every time you do that. Okay, can I ask you some specific questions around the incident, just to maybe get a little bit more information? And if they consent to yes, you can say, okay, can you tell me like what was specifically going on? And sometimes I will ask specific questions. I'm going to be clinical here. Is it anal, vaginal? Is it a digital assault? So using the word assault instead of rape, because rape is strong language for survivors sometimes. And so matching where they're presenting to you and not saying, oh, yeah, you're a survivor of domestic violence. Some people will come to you and not identify as a survivor of violence because maybe they've never been physically assaulted. Well, this is where we allow the clients to be in control of the conversation. We maybe show them the power and control wheel. Again, this is if you have those kinds of time. But matching client language is so incredibly important in establishing rapport and safety in these conversations. This is a really trauma-informed approach. And on this first page, you only need to check one of these boxes, the first three, for a person to qualify to apply for a petition in that county. And again, my practice, so does the respondent live in this county? Did the incident of domestic violence, et cetera, happen in this county? Or do you live in this county? If all three apply, check all three. If two apply, check two. If you're not sure what county to file it in, you want to ask us the question, reach out to us. We'll help you answer that. And then with the I'm checking this petition, I wait until after I've gotten the narratives to check these boxes off. That's my practice. And you may have some information prior to, if a client has a police report. So maybe you work with law enforcement, or maybe you became aware of this incident a little bit before. If there's things that you can help to prepare in filing for this, or helping the client prep for the conversation where you're going to file, absolutely take advantage of that. Hey, the timeline conversation, or if you want to jot down a couple things, I'm going to ask a couple questions of, where did it happen? Where were you at? So what's the address? Who was present? You can write those names down, and then just give me a little bit of information before and after. Did you file a police report? Okay, go ahead and send me that information, because sometimes it takes us a couple days to draft a petition if you have that luxury. Sometimes it's a quick phone call. We get one or two incidents in, and we got to provide a lot of information in a short period of time. So next, which page?
Family
Again,
household members, think we should skip for now. We can talk about that a little bit in the relief part. I think we just want to talk about this just a little bit, because if you don't have an address, it will be difficult to get the case done with. It is not required to submit it, but it is necessary to serve them. And we have seen courts dismissing cases for lack of service, which is frustrating. But I would put any addresses where they're likely to be found. Their last known address, any other places they're likely to be found,
family members,
family
work.
members' houses,
If
their
you
mom's house,
know
their work.
the times when someone's going to be there, that's how I've gotten protective orders served. I've called up the sheriff's office and I was like, they work from second shift. Can we get like special service on this PO? And that's where advocates, you can help advocate for that client and putting that additional information or contacting the sheriff's office, because POs aren't just served between 9 and 4, Monday through Friday. So it
Um,
might be a little more advocacy on our part.
Someone is saying that they reject any petition without an address. Put their last known address if you don't know their current address. That's what is required. If it's the house that they're no longer at because they fled, you put that address and then you get a better address later to make sure they're served. It's
You can
last known, not where they are living right this minute, because you won't always know that.
You can update the addresses with the sheriff's office even after you've put an address, if something comes about where you can. And then I think you passed where I was going to talk.
The relationship part? Or
You only need to check one box off in the relationship portion.
I think it
Um
might only let you check one off,
Yeah,
possibly.
they only allow you to check one off. I think the only caveat for this one is sometimes multiple things apply. If you are married and had children in common, both of those apply. I mark that we've had children in common. It's not a big deal if you don't, because you're likely going to put the children in the requested relief portion. But if
Yeah,
there's children,
this doesn't
yeah,
affect anything about your case at all. If
correct.
there's one of these that is disputable and it's the only one you can pick, then you maybe have a problem. Like, we are dating or have dated each other, or we have been in a sexual relationship. Those are maybe disputable things. But
Mm.
I would just pick whichever one is higher up on the list if that's the option. I think that picking the child in common one, if they have children in common, is the best practice, because then the judge will be alerted that there are children involved. So Emily already kind of explained this, but I think it's important for you all to read the protective order law, section 9, where it says what you can do in a protective order case. And this is the list from that. So this is basically the same thing, but you need to read these instructions out loud to the client. So some things you can file a protective order, request this relief, and have the judge grant it, and they don't have to schedule the case for a hearing. The respondent can ask for a hearing at any time in the time the ex parte order is valid, and you kind of have to keep the judge updated about your location. But the protective order will be in place, and they don't have to schedule a hearing. They often do, though, and you should not give people the impression that only checking these things will keep the case from going to court. And then there's a second category of things, and I don't know why they broke it up this way, but evict the respondent from my residence if you live together is in the second category. And then so are asking for possession of a house, possession of a vehicle, possession of personal property. So I gave some examples here of like keys to my car, my vital documents, my social security card, my birth certificate, my medication, my kids' clothes, the keys to the house. You can also include an order giving you possession of a pet. It comes up a lot that people don't immediately mention their pets. And I think it's really important to just actively ask about it because people are in crisis mode. They're probably worried more about their children. And then later on, they will be devastatingly sad if they didn't figure out what to do about their pets. But there are sometimes programs that can take care of them, and I would include them in here if they are able to remove them. I wouldn't include pets in this order if like the respondent is going to be staying at the house with the pets, because then you're saying that you need to take them, but you don't have anywhere to go. So this is just the property stuff. Leaving a house that you have a right to be at, giving me possession of that house, car, property, and then animals are counted as property in the law. There is a third category of things that you can ask for, but they cannot be decided until after you have court, meaning until after the other person has been served and they've had a chance to participate in the case. They can schedule parenting time. They don't normally do that, or deny parenting time in a protective order case. They would normally just do nothing. You can request attorney fees if you hire a lawyer. You can request rent for maybe a shared residence that you're asking for them to leave. You can ask for other types of money damages. And then one last thing that I want to make sure we talk about within the last few minutes is guns, because the post-hearing order can include an order to surrender firearms. So I'm going to go to my cheat sheet
Before
on
you do that, one last thing on the
yeah.
petition is the public mailing address. If when you're doing safety planning, if the client is somewhere safe now where the respondent has no idea where they're at, you want to ask them, is there an address where this person is aware of so that you don't want to make their safe address a known address? And so it may mean that they choose not to file a protective order. And that's okay if that's the response. If they've
And
got
like if they're in a
a
different state,
family member.
duper
Yeah.
safe. Yeah.
If there's a friend or a family member's address that they know of that they can do that, there you will have to put down an address. If you have an attorney, of course that'll be the attorney's address. But in general, just as like a safety planning tip, don't make a safe address not safe by posting it, because adverse will get a copy and find out where this person's living.
You could also get a PO box, but I wouldn't do it in the
Mhm.
town where you're living if it's a new town. And then there have been a few cases I've heard of where the judge is like, "Well, I can't tell him where to stay away from if he doesn't know where you live." That is wrong. You might even bring this up to them. If the address is super duper important to stay secret, say, if the judge asks you to provide that address, you might alert them that there's a to read the section of the protective order law about addresses. It's section 7 of the protective order law. And it says, they might want to bring the law with them if they're really worried about keeping their address secret, that the judge can request their real address and have it on file. The judge can, they don't actually need it. And then they should only provide it to the respondent if it's absolutely necessary. And I don't think knowing where to stay away from is a good enough reason. Otherwise, it would not be possible to keep anyone's address secret. A protective order is usually valid for 2 years, responding to the question, or another date scheduled by the judge. That is totally up to the judge's discretion. 2 years is what they put in as the sort of default, but the judges will often do 1 year. I've seen them do like 6 months or 3 months, which is very frustrating. And if there is a reason that it is necessary to keep the petitioner safe, they can grant it for longer than 2 years. They are allowed to grant it indefinitely if they specifically find that that's necessary. It's just not something that any judge I know will do. There is a special law about like having a lifetime one, but that like applies to almost nobody. So I wouldn't necessarily worry about it. We do definitely want to talk about guns because if you are going to court and the person you are filing a protective order against has a lot of guns, that is often a big concern. You all probably have had some training on like security, safety planning going to and from court. I would spend a lot of time thinking about that when someone alerts you that there are firearms involved. How far are you going to be walking from the car to the courthouse? When you are in court, remind the client they can ask the judge to hold the other person there for a few minutes so that you can leave and get out of there and not have any chance of running into them. And if they don't show up for court and it's the type of person who might ambush somebody while they're leaving, you might ask a sheriff's deputy to just walk you to your car after the hearing. It's obviously better to be safe than sorry, to come across as being a little over dramatic than to have something really upsetting or sad happen to one of our clients. So I think it is okay to be overcautious about firearms. And we live in Indiana where everyone is under cautious about firearms. So you will have to speak up about this for it to be taken seriously. When someone is in a particular relationship with them, a current or former spouse, or an intimate partner they live with, or they have a child in common, or a parent and child, after a protective order has had a chance for a hearing where the other person had notice and the protective order is granted, the other person will be, the respondent will be Brady disqualified, meaning they lose their right to possess a firearm during the length of time the protective order is active. That means they need to surrender any firearms or sell them to a licensed dealer. And the court will generally say that, but they will not, without some prompting, give clear instructions about how to do that. There is some prep you can do, and you can help a client kind of plan out how they're going to ask for this. This is a good time to mention. I recommend that a client have at least one piece of paper with a few bullet points on it, not a script, absolutely not a script, but at least one piece of paper that it would be fine for someone else to look at it. The judge may ask what you're looking at, and that would be fine because you're just going to write, what are the important things that I need the court to know? 3 or 4 incidents you want to mention, a list of the things you want the judge to do. And then the second piece of paper I would absolutely prepare in any case where you have a concern about guns is a list with the what kind of gun is it? What does it look like? Even if you don't have serial numbers, make and model, you can say it's a shotgun or it's a long, it's a long gun versus a handgun. It's a revolver versus a pistol. They can, look at some pictures or something if they want to try to identify it. They can just write like a black handgun or a 9mm handgun. They don't have to know the specific details, but you want to get the right number and type of firearms so that the judge can order them to surrender those firearms. Write a list down, bring it to court if there are multiple guns, request that they surrender it to law enforcement at the hearing. The petitioner should be ready to do that specifically. And then here's where it's going to be different from what the judge will do on their own. Ask for the respondent to be ordered to file a receipt that they got from the police with the court. If they're not ordered to do that, when they don't do it, you don't have any proof they didn't do it. And the police will not participate in a protective order hearing to tell you whether someone surrendered a gun. So you want to ask for the judge to order them to go surrender the gun, get the receipt, and then come back and file the receipt within a certain time. It might be a week, it might be 3 days, it might be shorter than that. But then if they don't do it within a certain amount of time, you can check and the court should have proof that they've done it. And if they didn't do it, you can ask them to be ordered to show up for a hearing to prove they didn't. And yeah, if this comes up in a case where you're seriously concerned about firearm safety, this is something that we would definitely be able to help with. I think Emily did a great job of covering the different types of things that you might want to prepare for your petition as far as like supporting evidence. Remember that those things are not in the record in the case when you show up for a hearing. You have to prepare exhibits in order to have those things be evidence at the hearing. And so, in addition to telling the story all over again as if the judge did not read your petition, you have to enter the evidence again as if the judge did not read or look at the supporting documents. I'm going to include with the packet a couple of things about preparing exhibits for court. One of the documents is like a rundown of how to deal with remote hearings. Sometimes people will need an advocate to help them prepare exhibits for remote hearings. But one of the documents is just a template in PowerPoint to drop photos into that you can use to make exhibits that have more than one page. So, I have 5 pictures of firearms and ammo. I want to make an exhibit about that. There's a template in this packet that you can help people use PowerPoint to drop those photos into a document. It has a little like fake exhibit sticker, and you can save those as exhibits, and it might even be helpful to prepare them like that way for the petition so that they're ready to go for court and they're clearly labeled when the judge is looking at them. So if you have 5 pages of text messages that you've screenshotted that have some overlap that start at the beginning of a conversation that get to the end of the conversation, you want to put those texts in order in a single document that has several pages. I think that template can be helpful for that. I would also use that for several photos of injuries during a single incident, because you may have 2 or 3 incidents that each included some physical injuries. What if the judge doesn't look at the submitted evidence? Could you unmute and say more about that? Like, do you mean if they don't look at the evidence attached to the petition? Because you won't have a way of knowing that they don't do that. But if you go to court and you explain what an item is and why it's relevant to the case and how you know it is real and accurate, the judge will likely look at the evidence unless it's not something that even a lawyer could submit. So police reports, you can't admit those in court. I would attach them to the petition because they show the judge the information they kind of need for background. But photographs that you took of your own injuries are admissible in court. And if you say the right things, which are also in that document I'm sending you all, you can and expect the judge to accept evidence. If the judge says, I don't want to look at anything, you should call me after the hearing. But I think there's usually more of a problem of people showing up with like a stack of 100 pages and the judge just sort of taking it without really clearly saying what they're going to do with it, than judges saying, I don't need to look at any evidence and then denying a protective order. They don't usually make errors that obvious. They usually make errors the other way, where they're not really formally taking evidence and they say they're, taking it, but they're not like saying this is exhibit 1, it's part of the record, because when they're not going to grant a protective order, they won't make errors that can be easily appealed. But if you go to a protective order hearing, the client has documents that are well organized, printed out, ready to be handed to the judge, and they say they don't want to take them, you should call us about that. 1 minute for the last couple points. You can ask to renew or extend a protective order at the end of the 2 years. You still have to prove there's a threat at the time you're asking to extend it. You don't have to prove that there's new violence, but it is important to show some violation or other circumstances that make the credible threat still present. Then I want to mention that the last few slides of the PowerPoint and the outline I'm going to send you include a few final things like what to do if a protective order is filed against you, just a very brief overview of the other areas of law that are related, some of the benefits of getting a protective order that we are not going to talk about today, and then links to other resources. I'm going to go back up because there was one last thing I wanted to say. Protective order courts sometimes are dealing with 2 cases at once. There's a little summary of what you do and when each side has filed a protective order, or when only one side has filed for protective order and the judge feels both people are sort of involved. Since we are out of time, I'm going to skip our little quiz thing, but I am going to include that in the packet. Emily, are there any final points that you want to make?
Please feel free to reach out. My job is really to be connected with every community partner. If you want a more specific presentation for your organization, we also do stuff like that related to working with. I do presentations on how to work with clients in crisis, neurobiology of trauma related to domestic violence survivors. You're going to get a lot of that. Core 40 is excellent. You're going to remember maybe half of what you've learned, but know who the people are to come and ask. William and I are a resource for you. It doesn't matter what part of the state you're in, what organization you work at. Please, please, please feel free to reach out and ask us any questions you have. Community partners have me on speed dial and will call me up and to do like a consult. Happy to consult on a case, on a situation. And immediately, if I know you need to do an intake, then I'll help you with that. If you've never done an intake with a client at ILS, I can also walk your organization through that or advocate on how to do that, so that clients have support with that and requesting legal assistance. So I think you guys probably get a break now and need it.